Can everybody hear me? Okay, great. I just wanted a confirmation that you can hear me, and we'll just start in a couple of minutes here. There you go. Just wait a couple minutes for a few more people to join, and I will start the presentation shortly. All right, I want to respect everybody's time, so I will start, and as people join, I guess they'll join us at a later time. Well, first of all, thank you for joining. I know it's Friday lunchtime, so probably most of you are running either for lunch or already out of the office if you work from an office. So I will try to keep this within an hour. Now I have quite a few slides, so I'll try to go over them and see if we can cover all the materials that I have for you. My name is Dobrina Uston, and I'm an immigration attorney. I'm based in Dallas, Texas. That's where my office is, but we have clients all over the United States. And outside the United States, of course. The reason I decided to do this webinar on NIW EB2 National Interest Waiver is because we've been getting a lot of inquiries about it, and I just wanted to provide some information to the people, who are thinking about it, who don't know anything about the NIW, or just want to learn something new. Just a disclaimer, I will try to answer questions at the end of the webinar, but I will not answer detailed case-specific questions. So if it's something general, I will try to answer. If it's case-specific and it relates to your case, I encourage you to email me if you want to follow up. I just don't want to spread your information on this webinar. So as I said, this is my information. You can follow me on Twitter, LinkedIn, YouTube, although I'm not too active on YouTube, but getting there. And this is my email and office phone number. So let's start. So what is NIW? NIW, generally speaking, allows you to apply for an employment-based visa, even if you don't have a written job offer, or whether or not the job offer was cleared through the labor certification at the Department of Labor. So it's a pretty big deal. You don't have to have an employer in order to apply for the NIW. You can self-sponsor. Even if you have an employer, they don't have to sign off on the paperwork. They don't have to sponsor you, so to speak. But the requirement is that you have to show that the employment in the United States would greatly benefit the nation. So it is true that you don't need an employer, you don't need sponsorship, but you still have to show how your work it's going to benefit the national interest. And I will go into that a little bit later in the presentation. Here, this is not on the slides, but I just wanted to mention. So EB2 is the employment-based category 2, and if you're Indian national or Chinese national, as you probably know, there's a lot of backlogs in those two for people coming from those two countries. So for Indian nationals, it might take you 10 years until you're eligible to apply for the green card. So just wanted to mention that, and if you have any questions on how that works, let me know. All right, so who qualifies? generally speaking, people who apply for employment-based second preference would apply for an NIW if they're eligible, obviously. So the following people can apply. So we have two main requirements. People with advanced degrees in science, arts, or business, or minimum of a master's degree, or the equivalent. Equivalent is bachelor degree plus 5 years of experience. So either you have a master's or above, or bachelor degree plus 5 years of experience in your field. So that's one way you can qualify. The second way you can qualify is they're the people of exceptional ability in the science, arts, or business. I'm not gonna focus on the second requirement in this for this webinar. That's a whole whole different webinar, and it's gonna take another hour or so to go over this. But I just wanted to provide you the basics, the entry criteria for NIW. In terms of exceptional ability, here's the criteria. You have to meet 3 of these. Obviously, I always tell clients, if you are claiming that you're of exceptional ability, you're for a national of exceptional ability, you better meet more than 3. So we have official academic transcripts, records showing that you have a degree, letters documenting at least 10 years of full-time experience in your occupation, a license to practice your profession, evidence that you've been commenced a high salary, membership in professional organization, recognitions for your achievements, or other comparative evidence. As I said, this is a completely different webinar. It just takes a lot of time, so I will not go into the exceptional abilities for the purposes of today's presentation. All right, so what is the criteria for NIW? So let's say you have your PhD or master's plus 5 years of experience, and you met the minimum, the entry requirement. Then we have 3 prongs. We have to meet all of them. Number 1 is the proposed endower has both substantial merit and national importance. You're well positioned to advance the proposed endower, and it will be beneficial to the United States to waive the requirement of a job offer and thus the labor condition application. So we'll start with prong 1. The proposed endower has both substantial merit and national importance. So you have to meet both of these. Substantial merit, to meet that, we have to focus on the proposed employment itself. It does not require showing of significant impact, as USCIS realizes the pure science and furtherance of human knowledge are valuable. So pretty much substantial merit, it's not that hard to satisfy. I mean, anything, almost anything that you do has substantial merit. In that area, in the national interest waiver area. National importance. Sometimes people, at least the things that I have seen, like RFEs or denials for national interest waiver. What is the national interest? The way I see it, and at least the way I do it in my petitions, this is the first thing in my in the petition that I put. So to set the tone and for the adjudicator to know what are we talking about. So national interest, is it 5G? Is it AI? Is it healthcare? Is it education? Is it something else? So that has to be the first thing that the adjudicator basically sees in your petition, so you can set the tone. So how do we know what is the national interest? Somebody recently asked me, is there a list, like what is national interest? No, there isn't a list. Usually we have to examine the impact of the endower. So how is the impact going to benefit the national interest? listed in the PowerPoint, USCIS will look at the broader implications. Generally speaking, the way, I show the national interest. So let's say you tell me you're in the 5G field. So usually what I do is, I'll go through all the government websites, even, the White House website, Department of Labor, any department related to your field, and see what is the United States doing in that field. Are they investing? Are they pouring billions of dollars? What is it that they why are they interested in that field? So once we figure that out, then it's an easier argument to say, well, look, United States is pouring $10 billion in that field. Clearly my field is of national interest. And I have a small anecdote here. It was, so we had a client that was in the 5G field. I keep mentioning because, we had a few of those. And it was at the time when, I think it was a couple years ago, when as I was drafting the petition and we were prepping the documents, the president tweeted how important is 5G, and that we should be working on 6G. Well, guess what? To the presidential tweets are government records, so we printed. That was Exhibit 1. Case got approved, but that goes to show that obviously we have established the national interest. So that's just one example. Then obviously, if it's something, if you're doing work with the DoD or the military, obviously, we are going through all these websites and getting, information from them to see, what is it that they're doing, how much money they're spending, and why this is of national interest. So that way, at least we don't have issues with national interest, and USCIS does not send us an RFE and asking us, well, what is the interest here? We move on now to prong 2. So foreign nationals' position to advance the endower. Here, for the second prong, the focus is on the foreign national. So we know substantial merit. We know, the U.S. cares about the interest. Now, how are you positioned to basically further that national interest? The question is whether the person actually will be able to advance the proposed endower. USCIS looks and analyzes the following. So they will look at your education, record of success related or similar efforts, knowledge, plans for future activities. This works really well for startups and entrepreneurs. Progress towards the endower, what have you done, what's in the pipeline, the interest of potential customers, investors, and other relevant entities, or a model plan for future activities and any progress that are made towards achieving the activities. So these are broad categories. There's a lot of ways to satisfy, to show how you satisfy that category. Every case it's different. Every case takes a different direction. It's a very diverse field, so it just depends on the candidate and what kind of evidence they can produce. The second prong, generally speaking, that's where sometimes USCIS will send a request for evidence because sometimes people do not necessarily explain in great detail how exactly they're gonna further that national interest. Again, they will consider education, skills, knowledge, record of success, progress made, and interest of other related parties, such as user, customers, and or investors. So the last point is key. Sometimes we have entrepreneurs or people or startups that their founders want to apply for National Interest Waiver, and then the question is, well, great, how do I show that, I can actually, further the national interest. And obviously, if there's interest in their product or services that they're providing, and we can get contracts from their, existing clients or perhaps a future client, then that's how we show, that there's interest from third parties. Obviously, if you have investors, that's a big winning point as well. I mean, if somebody will spend or will invest, $1 million into your product or into your startup, clearly there's interest. So that's on the second prong. The third prong, sometimes that's also where issues could arise, and USCIS will send an RFE, is that they want to see that on balance it would be beneficial to the United States to waive the requirement of a job offer and thus a labor certification. So let me explain really briefly. That's not in the PowerPoint. What is the labor certification? So when a foreign national wants to apply for a green card through their employer, the regular green card process goes through the Department of Labor. So what happens is you have to have a job offer. The employer needs to do recruiting for your position and prove to the Department of Labor that there's no qualified candidate for your position, for that position. So obviously that takes a lot of time, especially now during the COVID situation. It's more expensive. The employer has to pay high fees for advertising and legal fees and whatnot. And obviously there's a lot of risks involved within the process as well. So the labor certification, why do we have it? Because the United States interest is to protect US citizens and ability and for their employment. So that's why we test the market. The employer interviews people, and then ultimately they have to show to the Department of Labor that they couldn't find the right candidate. Therefore, they're moving with the application and they want to, sponsor, you. So that's the interest of the United States. So that's what we're talking about when we say the balance. So what is the balance here? Well, the balance is that when you file for a national interest waiver, the USCIS will determine whether the benefit derived from you, from your participation in the national interest field, must considerably outweigh the inherent interest on the labor certification process. So we are balancing two things: your experience, what you bring to the table, your knowledge, and how all that, or your work, and how all that will basically outweigh the inherent national interest of labor certification to protect U.S. workers. So we have two things here that the USCIS tries to balance, and it's up to you to tell them, or convince them, that you're on the winning side. That what you provide is basically, it's considerably outweighs the interest in protecting U.S. workers. How do they do that? Well, they'll consider whether the nature of the endeavor makes it impractical to present a job offer or obtain a labor certification. So sometimes people that apply for the national interest waiver, they have unique skills. Sometimes they have multiple degrees. They have bachelor's in chemistry, master's in biology, and then they go on for their PhD, and then they would add to that unique experience that would be very, very hard to put on a labor certification. I'm not going to go into the details of labor certification, but generally speaking, for labor certification, the employer needs to put the minimum requirements for that job. So if you have, if you have a PhD and if you have unique experience, how do you put minimum requirements? Clearly, it's not gonna work. So they assess, your qualifications, degree, the uniqueness of what you do, your knowledge, and then they will consider whether it's actually outweighs the labor condition application process. Also for entrepreneurs and startups and self-employed people, it's well, you cannot do labor certification if you're self-employed. So that's another consideration that the USCIS has to assess. So generally, generally speaking, you have to flesh out your uniqueness. Sometimes, obviously the degree that you have, maybe you've taken, unique classes, maybe you have unique certifications, and I'll go into the types of evidence that we'll need a little bit later. But that's how, generally speaking, we will establish the uniqueness of your work and of your knowledge. As I said, this is one of the prongs where usually USCIS will send an RFP if they cannot really figure out, why you're special. I mean, I always tell people, when they, when we start the process and, when they answer my questionnaire, I'm like, always, as you're answering, always think, why me? Why am I so special? I know sometimes it's really hard to talk about yourself. I hate to talk about myself, but you have to, in this process, you have to do it. And as I said, the USCIS will consider whether on balance it would be beneficial to waive the job offer and labor market test requirements. Factors to be considered, as I said, the foreign national background, whether it would be impractical for the foreign national to obtain a job offer and labor certification. As I mentioned, you cannot self-petition yourself for labor certification. If you own shares of your startup, you cannot do the labor certification, unique skills and knowledge, and so forth. They also look whether it will still benefit the United States if other qualified U.S. workers are available. Whether U.S. interest in the foreign national contributions is sufficiently urgent to forego the labor certification. So I always put an argument in my brief about urgency. Obviously for some fields it's easier than others. If you're in the healthcare field and or you're doing cancer research, or especially right now, you're involved with COVID. Maybe you're on the team that is trying to find a vaccine or treatment. Obviously that's really urgent, so there's always has to be an urgency argument in that petition, because if that's to get a labor certification, if you have to go through that process, it could take a year or 2 years or who knows how long. So and that's why we have to convince the USCIS that what you do it's urgent, and without you doing it and without you working, that would hurt the national interest, whatever that interest might be. And you can establish urgency in a lot of fields, obviously, but the one of the easiest one is obviously healthcare. Everything is urgent there, especially nowadays. They will also look at the emphasis will be given on the foreign national standing in the field. What do others in your field think about your work, and all that will come in the letters of recommendation, which I'll cover in a couple of slides. And they will also look at your history of contributions, critical role you played in successful projects, obviously, and the alien's contribution in terms of their practical significance. You don't have to have all of these. These are some of the things that the USCIS will consider, and obviously the more you have, the stronger the case and the more credible you sound. So here are a couple case examples, just for you to see how USCIS is thinking for the most part. when they're looking at these cases. So USCIS denied an NIW for a medical researcher whose research lacked immediate clinical or practical significance and resulted in untested theoretical models. So in this case, it sounds like, yeah, they were, they were doing research, but nobody was really interested in that research. Wasn't tested, and they couldn't establish, how is that in national interest and what is the impact of that research. Obviously, if it's not tested, it will be hard to see or at least argue on some scale for the impact. On the positive note, the USCIS approved an NIW for a postdoc researcher in the field of chemistry developing antiviral and anti-cancer drugs, contributing to the health of millions in the United States. So that was a direct contribution. People were interested in that research, probably implemented that research, and ultimately the NIW was approved. So here you see two cases in the medical field, healthcare. One gets denied and the other one gets approved. And the third one was for a opera singer who brings the arts to the society and contributes to the body of knowledge on vocal health. So NIW is available for the arts as well. Pretty much any field that you could think of, we can make an argument for an NIW, assuming that you qualify and you have the proper qualifications, experience, and education. So these were the three prongs that you have to establish in order to get an approval on a NIW. Now, how do you do that? That's the $1 million question usually. So here is the evidence that needs to be submitted with your petition. They look at publication, citation record, letters of recommendation, government funding grants, memberships, awards, published material about the foreign national, patents, contracts, licenses, and technology transfers, evidence of others relying on your work. So you don't have to have all of these, or you can have more, but these are some of the basics that we go off of. And I will go over each requirement so that you can get an idea as to what type of evidence you're looking at. So publication and citations, including journal articles, book chapters, and books. So you have to provide a complete publication record, should be included with the petition in order to demonstrate the alien's past record of scientific achievement. The publication record should be accompanied by a citation record in order to demonstrate the influence of alien's work in the field. Journal impact factors and average citation records for the field can be used to show that the alien has a degree of influence above that of an average researcher. And then the $1 million question is always, how many citations and how many publications do I need? Do I have to have 100? Do I have to have 1,000? The reality is that there's no definite number of citations or publications. So each case, it's so unique that sometimes, you might have 1,000 publications and you can still get it denied. And the opposite is also true. You might have, 2 publications and you can get it approved. So how does that work? Well, this whole, obviously, NIW, it's very subjective. So, the officer, when they look at your application, they have to decide, okay, so are you qualified, and basically, how famous are you in your field, and what is the impact of your work on the national interest? So there are different types of cases and different types of strategies, that might work for some and might not work for others. What do I mean by that? So sometimes, I had a case where the person had a master's degree in computer science, had one publication as part of their education, as part of their degree, and that's about it in terms of publications. So why did he why did we get it approved? Well, because his work. So his work was in healthcare, in the healthcare field, and what they were doing, he was behind the algorithms for a product that they were installing in some of the major hospitals in the United States. So clearly we were able to show the national interest, his qualifications, and the impact he had on national interest. And then obviously, we got letters of recommendations from the different hospitals, from the doctors that were utilizing their product, and basically how that product was helping the doctors, was helping the patients, and ultimately his NIW was approved. Now, only one publication, and I think he had couple citations as a result of that. I don't remember. It's been like a couple of years now, but. So yeah, so there you have an example. Now, if you obviously, if you're a, if you have a PhD, and if you if you tell me that you have one publication, maybe that's not going to be, and no employment track record, then that might be problematic. So that's why when I look at these cases, we usually sit down and sort of see which route we're going to take. Is it going to be the 1,000 publications that you have, or are we going to focus mostly on your work, or is it going to be a combination of the two? So back to my point, and I got some emails asking, oh, what is how many publications or how many citations do I need to have? I hope I answered that question. I know it's not a satisfying answer, but that's the nature of NIW. Obviously, the more you have, the better. The more credible you sound. And that strengthens your petition. Now, on the flip side, do you have to wait until you have 1,000 publications? Absolutely not. Are you in a position that or are you in a position that you have only like a couple, but then if you tell me, well, in the next year or 2 years I will publish a bunch of papers, well, then maybe it's worth waiting and see how that goes. So basically just have to go case by case and see how we can develop that argument to basically establish a successful NIW. Okay, so letters of recommendation. So these are key. Basically, that's what drives, for the most part, your NIW. Independent letters of recommendation from those who have never worked or studied with you or advised your work will carry much more weight with the USCIS than letters from dependent recommenders. And this should be taken into consideration when you're selecting people who will be recommending you. So what does that mean? What is an independent letter? Well, a dependent letter usually is from somebody who doesn't know you, you never met, not your friend, not your family, not your coworker. It's somebody who doesn't know you personally, but is familiar with your work, because your work is so amazing that either they heard about it, then they looked at your work, and perhaps they even furthered their own research or whatever it is that they do using your work. These letters are the best letters. Now, obviously, I understand we cannot all have independent letters. So usually the common recommenders are if you're a PhD student or postdoc, that usually comes from your advisor, your thesis advisor, perhaps colleagues that you work with on a project, conferences that you have attended and been invited. Sometimes we can get letters from the organization that invited you and why they invited you, and then they will explain the value that you provide in your work provides to their conference and so forth. Generally speaking, letters of recommendation, and I see it all the time with letters at the end, or towards the end, people, especially people that know you, they will talk about your character. Oh, he or she is a good person, amazing personality, irrelevant. So we cannot have USCIS doesn't care if you're a good person or not. That's not part of the petition. So sometimes people get carried away and they're excited, and they might really like you, and then they want to put like a couple sentences about your character. That weakens the letter and makes it less credible. So usually when I see that in letters, I just tell them you have to remove that. Letters of recommendation should discuss your research contributions and their significance in layman's term, and I'll talk about that towards the end of the presentation, and also comment directly on the benefit of your work to the United States. Why am I emphasizing to the United States? Because sometimes people will write in their letters how their work benefits the company they work for. That's very nice, but irrelevant. You can mention it, but that cannot be the argument in that letter, and you cannot establish basically that you're of national interest because your work benefits your employer. Letters of recommendation are also a great opportunity to demonstrate the implementation of one's work. And letters of recommendation from someone who has utilized, as I mentioned, your work and can explain how they have done so in their letter. It's a great way to strengthen your case. So these are some suggestions in terms of the letters of recommendation. Usually the ones that I get are about, well, it depends, but about 2 to 3 pages. The ones who come from your thesis advisor or a professor that you work with, they tend to be a little bit longer. That's okay. The ones, if the letter, sometimes I get like letters that are like 1 paragraph, and I'm like, look, I mean, if you're trying to convince somebody that you're of national, or what you do is of national interest, 1 paragraph won't do it. Now, I would accept 1 paragraph only if that letter comes from, let's say, I don't know, it comes from the president, let's say. Or somewhere high up in the government, then the fact that it comes from there, speaks volumes. So, but that's the only exception that I would make in terms of 1 paragraph letter. So I hope this kind of gives you an idea in terms of the letters and how they are structured and what kind of information we need to provide in order to convince that adjudicator that what you do is of national interest. Okay, did I skip a slide here? Letters of recommendation. Okay, government funding and grants. So these are really powerful. Obviously, not everybody, can have those, but a lot of scientists, a lot of researchers, after their PhD, and then they start work as a postdoc. They're through their school, they're on a project that is basically the grant is from let's say the DoD or the military. Now, obviously, you cannot directly get a grant from the DoD or the military since you're not a permanent resident at the minimum. But what happens is the school or that professor who runs the project gets the grant, and then they will distribute the money accordingly. So you end up working on a project that is sponsored by the U.S. military or by or DoD or NASA or whatever agency is out there. So why is that important? So sometimes if you are working on that project, most likely you're also, to some capacity, you're collaborating with someone from the DoD or the NASA or whatever government agency is involved. Sometimes they can actually write a letter for you. There's a lot of red tape in terms of getting it on a DoD letterhead and all that, but it is possible. So you can think about that. Those are very strong letters, obviously coming from the US government. So I usually, the second I, kind of evaluate the client and see that, they're working on something like that, I push them to, to work on that letter and hopefully get one. It is essential to demonstrate the foreign national's high level of involvement in the application for the funding and his important role in the research related to the funding. So, as I mentioned, sometimes, well, not sometimes, if you're not a permanent resident, at the minimum, you cannot get grants directly. Like, they're not going to deposit money into your account. But you can participate in writing that proposal, or you can work on the project, and then the school finds a way to basically distribute funds to you. So these are some pointers, for all the scientists that are on today's webinar to think about. Okay, so the next piece of evidence, memberships. Those are good to have, generally speaking. Not going to win your case, but also depending on, on the organization that you're part of. Usually memberships that from organization that you've been invited to participate or to become a member, those are much stronger than organization where, anybody can become a member. Like, for example, as a lawyer, I can sign up for an organization that is open to the public. Well, there's nothing unique about that. They just want my money. They don't care that, my what I do or my work or anything like that. And some organizations are exclusive, so you actually have to receive a formal invitation to join. They will review, your work, your portfolio, your CV, and based on that, you will get admission to that organization. So these are very, these are very strong for the NIW. Awards to strengthen the NIW petition. They need to be given specifically to you, and must be nationally or internationally recognized. Things like you being on the dean's list at school, not gonna help much. I mean, nice to have, obviously, but it's not something that will increase your chance of approval. Other local and state and regional sort of awards are not strong most of the time. So awards good to have, especially if it's something recognizable nationally, internationally. Local level, university, like work awards. Sometimes people, I've seen people give me, oh, best employee for March, best employee for the year. I mean, that's very nice, but not for the purposes of the NIW. Published material about the foreign national. The benefit of one's work to the United States can be shown by media coverage, well, obviously. If the articles or published material used as evidence focus on the foreign national and his or her work she performed in the field of endower, and the media enjoys national and international recognition, this will be helpful for the NIW. So, generally speaking, some people have it and some people don't. If you're out there and the media is publishing about you, it has to be major media, so it cannot be, your local school newspaper. Again, that is very nice, but not for the purposes of NIW. Now, if if there's an article about you or the work that you have done on a project or a product, and New York Times is covering it, well, that's what we are looking for. Patents, contracts, licenses, and technology transfers, those are helpful as well. I understand not everybody has those, but if you do, make sure that those are included in your application. A complete patent record accompanied by citation or commercialization evidence is significantly helpful for demonstration, to demonstrate your ability and your stance in the field. Other similar evidence, including contracts, licenses, and technology transfers, are also helpful. As I said, not everybody has them. If you have them, great. If you don't, don't worry about it. There are other ways to showcase your work. Now, as I mentioned, obviously, contracts and licenses and technology transfer. This comes a lot with if you're a startup or entrepreneur, we will have this type of evidence. It's common. Let's see, evidence of others relying on a foreign nationals' work. If the foreign nationals' work or assistance was requested by researchers from outside institutions, this indicates the impact and significance of the foreign nationals' endeavor. Example, you did a publication, it got published, and you started receiving emails and inquiries from other universities, other professors, other people in the industry, inviting you to participate or collaborate on their project. So usually when that's the case, we obviously we submit the emails. If possible, we also submit their whoever is inviting you to participate. What is their stature in the field. So these are really, really powerful if you have them. Documentation such as email correspondence and acknowledgement in major trade publications or major media is also good evidence. So as you see, you have a lot of possibilities. Again, you don't have to have all of this. Obviously, the more you have, the better. But if you, for example, if you don't have a patent or if you don't have an award, it's okay. There might be other ways to satisfy the requirements and ultimately to win the national interest waiver. Let's see here. Oh yeah, and I said it, and I'm just gonna provide a few tips in terms of how to file the application and hopefully succeed and get it approved. As I think I already mentioned that, you have to define national interest at the outset. I have read a few, RFEs from, USCIS, from the USCIS for, other applicants, and I'm reading it and I'm like, I don't even know what the national interest is here. So if I cannot figure it out, obviously, USCIS is not going to do it. Generally speaking, at least that's what I was told a couple of years ago, or actually more than a couple of years ago, when we had a meeting here with the local USCIS office. They usually have about 20 to 30 minutes to look through your petition, and that's basic, and they base their decision on those 20-30 minutes. So you have 20-30 minutes to showcase what you do and why is that important, and why you're the best person for the role. So that's why very important national interest right at the top. What else do I have? Oh yes, people are selfish. We all know that's a true statement. Where I'm going with that? Well, I mean, it's all nice, what you do for your employer, for the national interest and all these things. But then, to sort of get under the officer's skin, you have to be able to relate to that officer. Why, how is your work ultimately might help them. That's why I say, people are selfish. So if you're able to relate to them, you have way better chance of winning or getting your case approved. How do we do that? Describe your work in simple terms. Describe how your work benefits the national interest, obviously. Describe how your work benefits your employer, but don't go too crazy about it, only a few sentences. And at the end, describe how that could potentially benefit people. when I say people, I mean the officer, because he or she is the one who is reading, who is reading your petition. And the way I see it, it's like a funnel basically. So let's say the field that we have, let's say it's a cancer research. Okay, so what is the national interest? Well, healthcare, cancer research. Then you have your employer. So you start with the broad category, national interest. There you go. Then you have your employer, increase revenue. Your work will increase revenue, get more customers. All that kind of fun stuff. And then you go down to the individual, basically promising cancer treatment, and because of you, the officer, if they get cancer, they might live for another 30 years. So this is just an example. I'm not saying that you have to do that, but I've sort of done it. Obviously, when it's relevant, and that's the field, obviously. So, and you can do that pretty much to all the fields. It doesn't have to be only healthcare, it doesn't have to be technology. We can always relate what you do, starting from the national interest to employer, and ultimately going down to that person who might read your petition. Because, like, for example, in this instance, imagine the officer is cancer survivor. Immediately he won't even care, or she won't even care about anything else in your petition. Or they have a relative, you just don't know. And the biggest tip, you probably heard that before, simplify. Do not use complex and scary words that no one can pronounce. This is definitely not going to impress the USCIS. And usually what happens is, especially in the science, in the STEM fields, sometimes we have, obviously, we have complicated words, complicated terminology. We always have to break that down in simple terms. Sometimes, I see petitions or, letters of recommendations where, I'll read the letter, and then at the end I'll be like, I have no idea what they just said. I mean, absolutely clueless. And, if I'm clueless, most likely the officer will be clueless as well. They will not go and get a dictionary or Google your terminology. That's not going to happen. You can use the terminology, but you make sure you define it in your petition. So that way, at least you give them the impression that, look, I mean, I know it's like 100 letters a word, but here's what it means. So hopefully that will make them happy. But yeah, generally speaking, you just have simplify. The same thing is for processes. If your work involves complicated processes, these have to be explained in a way that as if you're explaining to a 2-year-old or 5-year-old. So that's the best way to basically relate in lay terms what you do, how you do it, and why is that important, and why is that in the national interest. Sometimes it's hard to do, and it takes more time, but 100%, 100% worth it. Because what happens is, if you submit complicated stuff, we'll get an RFE because they probably didn't even understand what you were trying to say, and then and then we have to redo the whole thing again and explain to them. It's actually pretty simple. So I think that was my last slide, and I cannot believe that I went through like 22 slides in almost an hour. So if you have any questions, here's my information, and let's see if there are any questions here. Okay, you mentioned that some countries need to wait 10 years to apply for the green card, but during that time, can the petitioner stay in the United States and have a work permit? Could you explain more about it? Yes, that's a great question. So I didn't want to go into the, the technicalities of, like the visibility and how this whole thing works for the purposes of this presentation, but this is, since we have a few minutes, I'll answer that question. So for the purposes of the green card, so the National Interest Waiver, it's not a, it doesn't give you work permit. It doesn't give you, legal status in the United States. What it does is basically asking the United States, the USCIS, to approve your petition that you're of national interest. That's on Form I-140. For those of you who like forms. So once that is approved and you have a priority date, then you can move to the next step, which is the green card application. So whether you can apply for the green card or not, that will depend on your country of nationality. So for Indian nationals and Chinese nationals, there's a huge backlog, especially for Indian nationals EB2. I think last time I checked is 10 years, maybe a little bit more than 10 years. So until that priority date that you got when you applied for the NIW becomes current, you cannot file your green card application. What do you do in the meantime? So, and that's right into your question. If you have, let's say you have a H-1B, you can work, you can stay here, and you can wait for your priority date to become current. So that is one possibility. If you are on a H-4, which is the dependent on an H-1B visa holder, the spouse of a H-1B visa holder, and you have the EAD through them, then yes, you can apply for NIW, get it through, get your priority date, and then keep working on your EAD or other underlying status that is available to you. Just by applying to for a national interest waiver, you do not get any status. You do not get a work authorization. Now, what about if you're not from India or China? Then we look at the visa bulletin that is published by the Department of State every month, and we check whether your priority date is current. Rest of the world means everybody else minus India, China, Mexico, Philippines. Is usually current. When I say usually, sometimes we have backlog, sometimes it's unavailable. It just depends on how many green cards they have available. Now, obviously with the current situation and COVID and some of the policies, immigration policies changing, it's very hard to predict, where, what's going to be the next month with the visa bulletin. So I hope that answered your question. Okay, so that was one question here. Let me see. Okay, so some of these questions are, as I said, case specific, personal. So I'm not gonna discuss those on the webinar, but you're more than welcome to email me. Okay, so one of the questions is, doctors, are they eligible for NIW? Yes, they are eligible for NIW. Again, it depends on what they do, what is their track record, how famous they are, and basically whether they're gonna be of national interest. There was a just side note, there was a doctor, an MD, like a couple of months ago. She was on CNN, crying her eyes out because USCIS denied her NIW, even though she was in New York, first respondent, dealing with COVID patients, and obviously, was in the United States for 9 years, I think, did all of her education here, and then ultimately they decided that that's not of national interest. So she was on CNN, basically, she couldn't believe the denial, and after some media exposure, they quickly changed their mind. So the short answer is yes, doctors can qualify. It's just, we have to look at, each case individually. For clients you have worked with, what is the rate of acceptance? So generally speaking, the way I do it, I try not to take weak cases or cases that, if somebody tells me like, okay, let's just try it. But if I don't see that we have a case and we can, potentially prevail, at least 70%, if we have 70% chance, I usually don't take these cases, because sometimes, I'll review the resume, we'll have a chat, we'll have a consultation, and then I just won't feel that, I can assist that person. And that way, if I just don't like, wasting time and money and, basically giving false hope. So that's why, so far, all of the cases that we have submitted have been successful, knock on wood. But this is, also depends on, adjudication trends. So now the USCIS is obviously becoming stricter and stricter, for whatever reason. And, maybe they have a new policy, internal policy we don't know about. I don't know. But generally speaking, for me, it's important to see that we have a case. If I'm comfortable and confident that we have a case, that I can latch on something, that, I can make a decent argument, then I'll take the case. Yes, so there were a few questions about the PowerPoint. Yes, you will get the PowerPoint. Okay, so they're like, tons of people asking for the PowerPoint. You'll get the PowerPoint. How many recommendation letters? Oh, okay, that's a great question. So it depends. I know most of you probably hate that answer, but generally speaking, I tell people 8 to 10 letters. Now, if you have a career, if you have a 30-year career or 25-year career, obviously you will get more, or you can get more. And even if you get 20, they will not discuss the same thing. Now, if you just graduated, you just finished your PhD and you're in your postdoc and you have like a couple years of experience, between 8 and 10 letters, it's great, because after the 10 letter, things start to repeat, and we're losing that credibility. Nobody wants to read the same letter or the same information over and over again. Now, having said that, have I submitted with less? Yes, I have. Not by my choice. The client just, didn't want to get more letters. So I think the one that we did was with, the lowest number was, I think, was 5 or 6. But I usually don't recommend that, because it's, it's pretty thin. And, you most likely, the USCIS will send an RFE. So yeah, so back to my point, 8 to 10 letters, it's a good number. Okay, so fees. There's a question about fees. So government fee right now is $700 for the NIW. Government fees are going up at some point this year, probably by the end of the year or before October. In terms of lawyer's fee, I will not discuss that on the webinar. As I said, every case is unique, so it just depends on on the case, on how much work it needs to be done. Sometimes people are really organized and everything is basically just given to me. So it just depends on the case. So if you have if you have questions about that, you can email me. For the application, do I also always have to be the first author? No, you don't. That's not required. Okay, so here is a question that I don't think I know the answer, which is okay. I learned that the incorrect tax filing affects the success of the application. An international PhD student that had a child in the United States. So I don't do taxes. I know nothing about taxes. And for that, I would suggest that maybe, you take that question to somebody, either a tax accountant, a bookkeeper, a CPA, who deals with, international sort of, students, international scholars, and so forth, foreign nationals. So I've never heard, honestly, I've never heard taxes being an issue so far. So sadly, I cannot provide an answer to that question. Okay, so some of these okay, so this is a great question, and I get that a lot. I'm on a F1 visa in my PhD program. Can we apply for NIW while on F1 from a non-immigrant visa to immigrant? Will it impact on my OPT visa and etc.? So that's another one of those $1,000,000 questions. So generally speaking, when you apply for NIW, you don't necessarily express the intent to immigrate to the United States. You do that when you file for your green card. Now, I always recommend, and obviously, that will depend on, your country of origin. If you have to, if you have to wait 10 years or, 5 years, there might be different consideration there. But generally speaking, applying for NIW, filing form I-140, does not necessarily mean that you're changing your non-immigrant intent to an immigrant intent. And why is that? Well, because even if you get it approved, some people don't continue. Some people, doesn't mean that you're gonna file for your green card. Yeah, there's a high, chance, but some people decide that, or they get a better offer in the UK, for example, and then they leave. So generally speaking, not a problem. That's why I would always recommend that you just file for the NIW by itself. You can you can file for NIW and the green card. You can do a concurrent filing. And if you do that, then yes, then you won't be on an F1 anymore. They will take you out of service, and you will be, at that point, will be pending adjustment of status. And then if your NIW for whatever reason gets denied, then the green card application will get denied, and then most likely you won't be able to reinstate your F1 status, or leave alone getting a F1 visa at a U.S. consulate. So these are some of the considerations people need to make. Sometimes in cases of OPT expiring and you have nothing else coming up, you didn't make the H-1B lottery. Well, in that case, we will file concurrent filing, assuming we have a green card available. So we will file concurrently so that you can remain in the United States legally and get a work authorization down the road at some point after filing. But these are just cases where your status is expiring. There's nothing else. And sometimes, we just have to file. Some people, like, I don't care how strong my case is, I have to file so that I can get that work authorization and stay in the United States. Now, I wouldn't file the NIW necessarily day one of your PhD, so more towards the end of it, obviously. But I wouldn't worry too much about just filing for NIW. And that's what a lot of people that are on F1 do after they finish their PhD, and then they get the OPT. And yeah, remember, when you file the NIW, you won't have you can continue working on your EAD. You keep your OPT. As I said, that changes if you file concurrently for the green card. Okay, somebody wants the video. Hopefully it recorded. Last webinar, I don't know what I did. It didn't record, but I think this time we're good. Yes, you can get that. Okay, so I think, let me see if there are any other questions here. Okay, so there is, okay. Let's see. Can you give a specific examples for an endower that has the merit to win? I think I already mentioned, basically, I mean, anything, any area that you can think of, you could have potentially, an approvable NIW. It's not so much the endower, the type of endower, but it's more like, can you satisfy the criteria? Obviously, and no offense to anybody, but if you're in healthcare, well, clearly now healthcare is, in the news, every hour. What every hour? It's like, every 10 minutes. Anything to do with technology, AI, 5G, any of these areas, anything that is hot, right now, it's obviously might be slightly easier than, than, let's say, our opera singer. Not that, I'm not trying to, diminish the opera singer's capabilities and accomplishments. Not at all. I'm a former musician myself, so I know, I know how hard this is, but it's just that, the basically the what is the economy driving. So right now, if you have a successful startup, if you're hiring people, obviously in an economic downturn, this is, of national interest 100%. So yeah, so it just depends. As I said, anything can be of national interest. It just depends how how you argue it. Cannot see screen. Oh, okay. Okay, so somebody wants me to do webinar on EB1A category. Yes, I will do one. That's another area. Actually, that's one of my favorite areas in the immigration law. So I will do one in the next few weeks. I think I answered this. Does the publication has to be the first authorship? No. Yes, you can have the PowerPoint. NSF grant, yes. If the school gives me an award, I'll Ph.D. student award. Does that? Yes, but as I said, school awards, dean's list, not the strongest thing out there. Obviously, I'm not going to exclude them, but I'm not going to spend a paragraph explaining, how significant that award is in the field. Compare that to something that is national or international. So that's, obviously everything positive that you have about you and your work will go in the file. Now, how much weight and time we're going to spend actually, fleshing it out, that will depend on, how important that piece of evidence is and what USCIS will consider important. Yes, so for membership, do you think if I'm a reviewer of papers, organizations like journal conferences, definitely. That's one of the things we will definitely flesh out. Okay, so self-sponsor. So that means that you don't, so you can, let's say you work for, I don't know, Amazon. You don't have to go to Amazon HR or your boss and tell them, oh, can you sponsor me for a green card, for a EB2 National Interest Waiver? You can sign off on your application, and that's considered self-sponsor. Now, obviously, they can provide a letter of recommendation, but they are not the one actually, sponsoring in a sense that, they're paying for everything or signing the application. So that's what self-sponsorship means. Or you don't have an employer currently, or you're a startup. You can self-sponsor yourself for NIW by signing off on your own application. How is EB2 national interest different from O1? So EB2 national interest, you're actually on the path to a green card. So once you get the national interest waiver, your next application is the adjustment of status or green card. O1 is a visa. So O1, you have to have an employer or an agency. that is sponsoring and signing off on your behalf. It's given for 3 years usually, and then you have to renew every 3 years. And O1 visa is basically extraordinary ability. So you have 10 requirements, 10 points. You have to satisfy at least 3. But that's for another webinar. But the main difference is obviously O1 is just a visa, non-immigrant visa. You come, you work, and somebody has to sponsor you. Versus the EB2 National Interest Waiver, you don't have to have a sponsor, and you're applying for a green card ultimately. I think I answered the publication question. As an Indian national, with such a long way, what is the best way to get about getting a green card? So EB1 is, I mean, I think the wait right now is a few years, I think, maybe 3, maybe 4. Obviously you have to satisfy the requirements for the EB1. Right now, EB1 is they're really cracking down on the EB1. It's really hard to get through. Even for cases like super strong cases, you know, they'll just deny them. So it's a different, basically it's a different category, different standard. And they're scrutinizing these like crazy right now. So would I do it? Yeah, we do them. But again, you know, I have to have a case. Otherwise, it's just gonna be, you know, a miserable experience for all parties. Okay. Well, thanks for attending. Working in the healthcare field. So question is, I'm on a J1 visa currently working in the healthcare field. Can I apply for NIW? So there are a couple of considerations about J1s. The first thing is, are you subject to the 2-year home residency requirement? I'm not going to go into that. Obviously, you know, if you have a J1, you should know that. It's either in your visa, stamp in your visa, or the DS 219. Now, generally speaking, you can, but we have to look at whether you have that requirement, whether you can waive that requirement, what country you're from, and how long it's gonna, because the thing is, if you have the requirement, the 2-year residency requirement, and you get the waiver to lift that, you won't be able to extend your J1. And if you don't have anything else lined up, like you know, H1B, then you will be out of luck. So there's a lot of things to consider when it comes to J1 holders. You can I publish a paper? Product benefits. I'm not can I not publish any papers if I work? Oh, okay, get it. If I work in a company, product benefits. Yeah. As I said, I have done it. Just one publication. The person had one publication as part of their degree, master's degree. Nothing significant. So, but you know, we focused on the work and how basically the work really impacted, you know, the people going to the hospitals. Have you seen any recent trends of road denial since faster, slower? Yeah, that's the $2 billion question. So USCS currently, I don't know. They're all over the place. They allegedly they don't have money now, so they're planning to furlough, like, you know, I don't know, more than half of their workforce. Obviously, that's not going to help with any of the backlogs during COVID. In terms of National Interest Waiver, I think Texas Service Center on the website, it says between 4 and 6 months. Maybe, I'm not sure. The ones that, you know, we are getting right now are petitions that were filed last year. So I don't know where they got that 4 to 6 months. Sometimes, you know, you file with the Texas Service Center, and then they're overwhelmed, and then your petition gets transferred to the Nebraska Service Center. So definitely slower. And now with COVID, we don't really know the impact yet that much, because they just reopened most of the offices. Even the ones that were working during COVID, they were understaffed, and now depending on how whether they're gonna be able to get funding in order not to lay off people or furlough their employees. So we'll just have to see. But currently everything is taking longer than it used to be. I mean, they always have backlogs. It just depends on how bad those backlogs are. Okay, how long does it take to get the I-140 with, yeah, I think I just answered that question. So, yeah, so it just depends on processing times, processing trends. There's no premium processing. I forgot to mention that. There's no premium processing for NIW I-140. There is premium processing for regular I-140, but not for NIW. So we cannot do premium processing, and that's why it takes they say it's 4 to 6 months. It's not 4 to 6 months. Count at least a year. Okay, I will email that presentation. I think you will get a follow-up email after the webinar. Okay, thank you for staying. Yes, hopefully it recorded. If someone is on H-1B cap exam, will be able to switch to a private company after getting I-140 NIW. So, so H-1B is one thing. So if you are on H-1B for a nonprofit and you want to continue with your H-1B for the for-profit company, you have to go through the lottery. Now, if you file for NIW I-140, you can, depending on your country of origin and whether the visa bulletin is current, if you file concurrent filing with the green card in addition to the NIW and you get your work authorization, then you can join any company you want. But that H-1B from a nonprofit will not by itself transfer to the profit. You have to go through the lottery for that. Does not having insurance during the F1 visa will negative the person when they want to apply? Insurance, like a health insurance? I'm not. I'm guessing it's health insurance. So not necessarily for the NIW, but because remember the NIW, the government is only looking as to whether you qualify. That's all. They don't care about your insurance. Now, when you apply for the adjustment of status, then you have to provide evidence as to whether that you have an insurance. I'm assuming it's health insurance, or if you don't, that you have the funds to cover, your medical bills, and that's a new, new requirement since end of February, and that's a whole different webinar. Does pending green card status automatically get us an EAD? Well, you have to apply. So when you file for your green card application, you have to include an application for work authorization, and then they will send you the work authorization at some point. Now it's about 6 to 7 months. So there's backlogs for those. Do you have any thoughts on upcoming immigration? Yeah, that's the $3 billion question. I know there is a lot of talk and in the media and everywhere about restrictions. I don't know. I think they're getting. I mean, we were expecting that to come last week. But they're getting a lot of pushback from different interest groups and companies like Facebook and Google and Microsoft. So we don't know. I think there will be something coming up. To what extent, what they're gonna restrict, their main pain from based on what they've been doing throughout the last 3 years and a half, their main pain is the OPT and STEM OPT. So these are two things they can basically suspend. Whether they're going to do it, I'm not sure. In terms of the H-1B, as you probably know, they want to, the only damage they can do is prevent new H-1Bs from entering the United States. Meaning, if you are, let's say, you went through the cap this year, and you're currently sitting outside the United States and waiting for October and waiting for your visa interview, these H-1Bs, those are the H-1Bs they want to prevent from coming to the United States. Now, I mean, currently, all consulates and embassies are closed. So even if you want to go get a visa stamp, you can't. So I'm not sure, how that's gonna intertwine with the actual suspension of new H-1Bs. And I also saw a few, people were saying also the L-1As and H-2B and other, non-immigrant work visas. But we just don't know. I think there will be something, but to what extent and how much, damage it's gonna create, hard to say. But once it's out, yeah, I mean, we'll share the information, and most likely once it's out, there will be a lawsuit filed. So we'll just have to see. How much do you charge for a consultation? Okay, so on fees, please email me privately. 2 years home, can I apply for green card? I don't have. So I'm on a J1 with 2-year home residency. Can I apply for green card after J1 waiver when I don't have sponsor for H1B? That will depend on whether you can file for your adjustment of status and country of origin. So if you want to follow up, let me know. Basically, I think I already mentioned that if you have the 2-year home residency requirement and then you waive it, and that waiver is approved, you will not get an extension on your J1. So you have to be able, you have to move to H1B if possible, or you just, you won't be able to apply. So that's, it's a tricky, very tricky situation with the J1s, especially with the 2-year requirements. Okay. Okay, I think I already covered that. Will stem operative rescind, will that hold up to judicial scrutiny? As I said, that's their pain. It's been their pain since, for the last 3 years about the OPT and especially the STEM OPT. So if they suspend it or eliminate it, definitely it's going to court. Now, obviously with the courts, it's going to take, some time to go through. Most likely there will be some kind of injunction initially. So we'll just have to see, where things go with that. Hopefully they don't do anything. Hopefully we don't have more surprises. How much will it cost for NIW? Again, any fee questions, you can email me. Is there any chance they might remove the H-1B extension? So H-1B, so generally speaking, the administration, the president does not have the power to limit extensions and change of status for individuals who are inside the United States. What they can limit is people from entering the United States. So if you're outside the United States and you're waiting for your visa stamp, they might limit that. Now, whether they're gonna do it for extensions, let's say, you did your extension, got approved, now you're out and waiting for the consulate to reopen. Whether you're gonna get the visa stamp for that extension, I don't know. We don't know, how far they will go, if at all, with the restrictions. If I get married while NIW, do I get both statuses, or I need to? So if you get married, you can keep your NIW pending. Just because you have one petition pending doesn't mean you cannot file another petition under a different under a different section of the law. So some people do, depending again on the case, the situation, country of origin, they will file, NIW and EB1 at the same time, and see which one sticks. Sometimes, as I said, sometimes, NIW, it's slightly easier than the EB1. But sometimes we'll get an EB1 approved and then they'll deny the NIW. So it's just, weird. But you can apply, you can apply for multiple, immigration benefits. Okay, so if my current visa status is expiring soon and NIW is filing, but without a concurrent green card application being Indian or Chinese national, the date is not current. Can I still get EAD to work in the United States? No. EAD, you can get EAD only if you file. EAD is part of the green card application. So you cannot file a standalone EAD based on your NIW application pending. So you have to either get an H-1B or J-1 or anything that will basically keep you inside the United States legally. And as I mentioned, the NIW does not provide you with any status or work authorization. So so that's, it's important to keep that in mind. Okay, I think these are all the questions. I hope I answer all of them. On the more personal ones, you can reach out to me. Oh, and one last point is you can apply for NIW outside the United States. You don't need to be in the United States to apply for an NIW, and that's, sometimes it's it's quite common, and sometimes it's actually might be faster because the NIWs that are consular processing, they go to a different office, and that office or it used to be before COVID, slightly faster in terms of adjudicating NIWs. So just all right, I think that's it. Hopefully, well, I kept you more than an hour, but hopefully I answered some of your questions. Okay, so last question. What are the chances of getting RFE when F1 student applies for NIW? So as I said, they will not examine your F1 status at this point. NIW, if you get an RFE, that's going to be focused on the merits of the NIW. They're not concerned necessarily at this point with your status. Now, applying for, obviously, I would not recommend applying for NIW your first day of F1. But generally speaking, I mean, if you qualify, let's say, you have experience of 20 years, outside the United States, and then you came here, your postdoc, so forth, you can apply. But the RFE will most likely not be about your F1. If they send an RFE, it's going to be about the merits of the NIW, the evidence that was submitted, and the type of evidence they want to see. All right, I think this is it. Well, thank you for staying. I know it's 30 minutes over the time, but I hope I answered some questions and provided some information. So with that, I will end the webinar, and if you have any questions, here is my information. And you can follow me on LinkedIn or Twitter. I'm pretty active on both of them, or at least try to be. So that's it for today. Thank you, and until next time. Bye-bye.